period of 6 months from today for conclusion of the arbitral proceedings and publication of the award. Full stop. It is requested that the learned sole arbitrator shall make all endeavors to conclude the arbitral proceedings and publish the award within the extended time period. Full stop. With the above direction, the present petition stands disposed.
Extremely grateful, my lord.
May I please, your lordship, my lord. This is my application under section 29A of the, my lord, extension of the mandate. This is for the second time, my lord.
My lord, I'm not opposing the extension, but my lord, I'm praying for my lord, the arbitrator to be substituted.
No.
Substitute.
Yes.
At their instance.
No, my lord, because my lord, I'll
At
satisfy
their-
lordship. My lord, now the Supreme Court has clarified that, my lord, if the application for extension is filed after the mandate expires, then, my lord, the substitution is mandatory. I'll
Mandatory. How can you say mandatory?
my lord, may I cite, my lord?
Order.
Kind.
This statute doesn't say so.
Can't be
The
mandatory
statute
that
which he is referring.
Your lordship will
Copy.
consider, my lord. It's a recent decision.
Give me a copy or the citation of.
Veera. Shall be, shall be.
Who?
yes.
Your lordship will consider, my lord, paragraphs 12, 13, and 14.
Read it.
May I please, my lord?
Yes.
We are conscious of the fact that a two-judge bench of this court has interpreted the word terminate in section 29A4 while dealing with an issue whether an application for extension of time for passing the arbitral award is maintainable even after the expiry of 12 months or extended 6-month period, as the case may be. It has been held that on expiry of the initial period of 6 months and extended period of 6 months, the arbitral tribunal becomes functus officio, but not in absolute terms. It has further been held that the termination of arbitral mandate is conditional upon the filing of an application for extension and cannot be treated termination stricto sensu. It has also been held that the legislature, by using the word terminate, intends to affirm the principle of party autonomy. However, the fact remains that on expiry of initial period or extended period, the arbitrator cannot proceed with the arbitration proceeding and his mandate terminates, subject to an order which may be passed by the court in a proceeding under section 29A4 of the Act. An arbitrator or an arbitral tribunal is not always statutory. It is ordinarily a forum chosen by the parties for resolution of their disputes. An arbitral tribunal, with the consent of the parties, decides their disputes. In the instant case, as stated supra, the mandate of the sole arbitrator had terminated on 28th Feb 2023. When mandate of arbitrator has expired, his continuation is impermissible. Section 29A6 empowers and obligates the court to substitute the arbitrator insofar as submissions of the respondents, empowers and obligates the court to substitute the arbitrator insofar as submission of the respondents that since the petition filed under sections 14 and 15 of this, my lord, is on a different point altogether. Insofar as submission
observations have come, sir. It can't
Milord,
be that.
Milord, kindly, may I just place further, Milord? Kindly, Milord, just consider this. In any case, on 24 January 2022, the mandate of the sole arbitrator was not terminated. Therefore, the order dated 24 January 2022 does not have any impact on the decision of the petition under section 29A of the Act filed by the appellants. The substitution of a sole arbitrator is warranted when his mandate ceases to exist to effectuate the object of the Act, which mandates expeditious resolution of the dispute. In view of the statutory scheme and undisputed factual position, we are satisfied that the case warranted the exercise of jurisdiction under section 29A6 of the Act, the High Court erred in granting an extension when the mandate of the sole arbitrator had ceased to exist. Conclusion, my lord. For the aforementioned reasons, the impugned order dated 22nd April 2025 is quashed and set aside. The mandate of sole arbitrator Mr. So-and-so stands terminated by operation of law. Mr. Justice So-and-so is appointed as the substitute sole arbitrator. The arbitral proceedings shall resume from the stage already attained and be concluded within 6 months. My lord, identical case, an application was made, my lord, for extending the mandate of the arbitrator after the mandate had already expired. And the High Court, my lord, extended the mandate and, my lord, directed the same arbitrator to continue. Supreme Court said no, since the application itself was filed after the mandate had expired, time would stand extended, but there would be another arbitrator who would be appointed. My lord, identical, my lord, case. And it says that it obligates and it's necessary that a substitution. My lord, I don't personally, my lord, my lord, this is the law that is
This application has filed, my lord, during the continuance of the mandate of the
No,
arbitrator.
that is a wrong.
Consent to the extension, right?
That is a, yes, my lord, I'm giving consent to the extension.
My lord, can it takes out the section?
My lord, I'll tell you about the difficulty. My lord, it's becoming slightly embarrassing. My lord, we cannot afford, my lord, the arbitrator. Because, my lord, the fees is not being charged, my lord, as per the.
As per you,
different
you have
things.
named that arbitrator.
It will be, my lord, he's a, my lord, the learned
You have to
arbitrators are
take it
retired.
to the, see, the Arbitration Act is very clear to that extent.
don't
All
have the
these
funds.
things you have to go before the arbitrator. If you want anything, 16 you file it, 15 you file it, get him replaced, whatever you have to do. 29A, don't raise anything else apart from the extension. Not over here.
Good.
My lord,
You want to file your reply, you want me to pass an order?
my
Treating
lord, may I
this,
just consult my advocate on record, my lord?
Malikani takes the item number 10 also. This is my application under section 27, Mala, in the same matter.
My lord,
For appointment.
my lord, kindly allow me to, my lord, use an affidavit, my lord.
ওটা তো নিয়ে section 10.
Because, my lord, even if assuming that your lordship, my lord, distinguishes this decision, even then the discretion is there to consider appointing, my lord, another learned arbitrator. So, my lord, at least to that extent, allow me to, my lord, use an affidavit. In the meantime, hopefully, my lord, we'll accumulate funds. The only difficulty is, my lord, affordability. I'm being very candid. There's no other reason.
there's an application filed by
At
the
your instance,
petitioner
yes, Vinod.
under section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal to conclude the arbitral proceedings and publish the award. Full stop. This item number 4, right?
Item number.
Okay. Item. एक मिनट रुक।
I need.
This court-wide order dated 19 January 2023 appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. After the expiry of the mandate of the arbitral tribunal, the parties with mutual consent extended the mandate further by a period of 6 months. Full stop. This court, by order dated 19/3/2025, extended the mandate of the arbitral tribunal for another 6 months.
Another 8 months, my lord.
Another 8 months. Full stop. Now the mandate of the arbitral tribunal has expired on
8th December 2025.
8th December 2025. Full stop. Learned counsel for the respondent states that the present application, learned counsel for the respondent states that though he has no objection to the extension of the mandate of the arbitral tribunal, but seeks substitution of the arbitrator. Full stop. He states that in terms of section 29A, in terms of section 29A4, the mandate of the arbitrator stands terminated automatically, and that the substitution under section 29A6 becomes obligatory on the court. Full stop. To impress the said contention, he has relied upon a judgment of the Honorable Supreme Court, 2025 SCC online SC 2754. ये कोट करो, पार्टी का नाम भी देना और डिटेल पर. Full stop. He seeks and is granted 2 weeks time to file his affidavit in opposition. Reply to the same, if any, within 1 week. List after 4 weeks.
Let section item number 10 was
Item number 10, it should be
same order.
in, wait, not.
So, Malad, 10 is a different application.
Different application.
And Malad,
We'll have it, wait.
Wait.
Or take 10 also with this, where it's a 27 application. Right?
27, yes.
identical application filed before the arbitrator pending. Suppress, Malad, in this application. No leave of the arbitrator taken either.
27, you need to have leave of the arbitrator. You can't come.
No leave, they've just come to court.
Read 27.
My lord is asking you to read the section. You can take my book.
Yes.
You can't come here without the approval of the arbitrator. And if the application is pending, how have you filed it here? How have you filed it? Withdraw the application. Learned counsel for the petition seeks to withdraw the present application. The same is.
No, that's the application under section 26.
You want me to dismiss it or bear it?
26 is
cost.
pending.
Need to seek approval of the arbitrator before you move a 26. Read the
Yes.
provision, sir. What does the provision say? Read it.
Either by the arbitral
Approval of
tribunal
the
or
So have you
with
sought
the
the approval? Where's the approval?
no, there's no approval.
Then
I'm
How
withdrawing
have you
this
filed
one.
it?
I'm withdrawing this one, my lord.
That's what I'm saying. Withdraw it. Seeks to withdraw the present application. The same is dismissed as withdrawn.
Great.
Not maintainable at this stage. If you want to move a 27 for recording or additional evidence, you have to seek the approval
Yes,
of the
sir.
arbitrator.
Or
Then you move an application, will pass an order.
as it is.
In fact, with the prayer also is copy pasted. Your lordship has been referred to as learned tribunal. Learned tribunal is requested to direct such and such.
All cut, copy, paste applications. Huh?
Grateful. I appear for the respondent.
I appear on behalf of the petitioner. First extension introduction. First extension reading.
Date of appointment?
Date of appointment is by order dated 4th
Fourth
of January.
Only one thing, Lord, I'd like to bring to my Lord's kind notice.
Are you
Lord.
opposing it?
No, opposing, Lord, it's just a procedural error. At page, Lord, the time to start the, Lord, the time computation starts from 18th May 2024. 1 year ends on 17th May 2025. Thereafter that, Lord, extension which is by consent, that is nowhere recorded. And thereafter this application has been filed.
What has happened is that in the meantime, it was
So that
brought
is
to
a
the notice.
procedural error that has
There
to be
there were adjournments taken on the ground of the respondent, and we were in the middle of final arguments. I have annexed all the minutes.
adjournment
Lordship
is
will kindly see
irrelevant.
that by conduct, the parties have agreed to the exit. It is not recorded. I vowed on to you that. It is not recorded. And according to me, the timeline has expired on 18th of November 2025.
My objection only is to this extent, my lord, that this has not been done. Subsequently, this application has been filed.
It was pointed out to the arbitrator, but the arbitrator has realized that since the extensions were taken on the ground of the respondent, it could not have been recorded. But they have participated.
Where is it recorded? Please show.
It is not recorded. That's what I submitted.
I think it's not recorded. Oh, you don't have any objection.
I don't have any objection. Only this is the point that
The present application has been filed by the petitioner under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of the mandate of the arbitral tribunal for concluding arbitral proceedings and publication of the award. Full stop. This court, by order dated 4/1/2024, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 18/5/2024. Full stop. Thereafter, with the consent of the parties, the mandate of the arbitral tribunal was extended till
18th November 2025.
for a period of 6 months till 18th November 2025. Full stop. The said time period expired on
18 November.
18th November.
18th
It was still 18th November.
18th November.
Yes.
All right.
Final
Learned
argument
counsel
with your lordship. They are
Only reply is pending from their side.
learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration and submission of the parties and material placed on record, this court is satisfied that there has been no undue or unwarranted delay on part of the learned sole arbitrator in conducting the arbitral proceedings. Full stop. Keeping in mind the stage of the arbitral proceedings and in the interest of justice, the mandate of the arbitral tribunal is extended further for a period of
6 months.
6 months.
6 months. Full stop. 6 months from today. Full stop. It is requested, learned arbitrator is requested to make all endeavors to conclude the proceedings and publish the award within the extended time period. With the above direction, the present petition stands disposed of.
Great.
Lordship, can it be from the date of communication of the order?
The extent
From-
of 6 months.
From today,
Grateful. I bow down.
date of communication, then you don't know when you'll communicate.
No, I bow down, your lordship.
May it please the lordship.
Yes.
It's an application under section 29 capital A for extension.
4. I could not oppose this because my instruction is not to oppose. But Parad, I should
But
point
still you
out that
feel
the
like
court does not have the jurisdiction. Because this is a mutually appointed arbitrator according to them. This court did not appoint the arbitrator and the parties are outside the territorial jurisdiction. All the parties.
May I indicate?
Yes.
The sitting, kindly take up page 19. I have an answer to this. Page 19, kindly see at the top. Minutes of the 5th sitting held by the learned sole arbitrator at Case Roy Road, which is within jurisdiction. All the sittings in the proceeding have been held here. The seat and equivalent thereto by Arif Azim's judgment would be the venue which is within jurisdiction. If my learned friend can show that there is a proceeding which will be hit by section 42 of the Arbitration Act, then I have to bow down.
First extension?
First
First
extension.
He already has the consent
Indeed,
from his
indeed.
Take down.
And also that
When was the
paragraph is
arbitrator appointed? 19th? When was the arbitrator appointed?
the arbitrator was appointed at page 8, 12th December 2023. That was the notice invoking arbitration,
12th December.
12th December.
Any extension?
There's one mutually agreed extension, that's page 18, the second last paragraph. Proceeding, the second last paragraph gives the gist, page 18.
By the consent of the parties.
Proceeding was initiated by a letter of 13 December 2023. Pleadings completed. Parties orally agree for extension of a further term for 6 months. Consent extension for 6 months from 19 June.
All right, take down. The present application has been filed under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceedings and publication of the arbitral award. Full stop. The parties by mutual consent appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 19/6/2024. Full stop. The parties by mutual consent extended the mandate of the arbitral tribunal by 6 months. Full stop. The set time expired on 17/12/2025. Right. Full stop. In view thereof, the petitioner prays for an extension of the mandate of the arbitral tribunal for a period of
1 year, may I pray for me?
you have not asked for it.
Let be
Extension of the mandate of the arbitral tribunal. Full stop.
12 months.
Learned counsel for the
Paragraph 9.
respondent states that he has no objection to the application and for extension of the time period for the arbitral tribunal. Learned counsel for the respond number 1,
I appeal for 4, respond number 4.
1, 2, 3 as well as 4. Counsels for the respond number 1 as well as respond number 2, 3, 4.
But 1, 2, 3 are together, 4 is separate.
Oh, 1, 2, 3. All right. 1, 2, 3 and 4. Full stop. How many sittings have been done?
23. 24 sittings.
Upon consideration of the submissions and the materials placed on record, this court is satisfied that there has been no undue or unwarranted delay on part of the learned sole arbitrator in conducting the proceedings. Full stop. It is noted that already
24 sittings.
24 sittings have been conducted. Full stop. Accordingly, the mandate of the arbitral tribunal is hereby extended for a period of 12 months. From today, the arbitral tribunal is requested to make all endeavors to conclude the proceedings and publish the award within the extended time period. Full stop. With the aforesaid observation, comma, the present petition stands disposed of.
Deeply blessed. May I file the affidavit of service, madam?
Affidavit of service taken record.
Will your lordship, for our own benefit, will your lordship observe that since sittings have been held within the jurisdiction, this court will retain jurisdiction to extend that will be beneficial for us.
You're already raising that. Let the arbitrator decide on it.
Very deeply blessed.
Why get involved in these things?
And other matters, we would have to travel to the district courts and not we, somebody else would.
See, we are all awaiting a judgment of the Honorable Supreme
Yes,
Court.
and SLP
You
has
know
been.
that SLP 10954.
Yes, that has been
Let's
carried.
see when it comes. It's already been reserved in November.
My lord.
So hopefully it should come in whenever it comes. But till now, I think the coordinate bench as well as this bench
Yes, right. Endure
has
project.
consistently held the view that if the arbitrator is appointed by this court, then the mandate can be extended.
Then mandate can be extended.
That has been the view.
Yes,
Not
but if
So
the court has not appointed the arbitrator, if it is mutually appointed, then also whether the court retains and in what circumstances, that is
let the Supreme Court decide. We'll see that.
Very deeply blessed. madam.
grateful.
Seven, my lord, it is my application, my lord. Extension of mandate of the arbitral tribunal, my lord. My lord, kindly have a look, page number 7 of my application. Date of appointment of arbitrator, my lord, 23rd August 2023.
Page
Page number 7 of my application. 23rd August of 2023 was the date of appointment of arbitrator. Then, my lord, kindly have a look, page number 9. This is the, my lord, minutes of the last sitting passed by the sole arbitrator, my lord. I am reading, my lord. In terms of the earlier decision, the instant meeting of the tribunal was duly convened. Rejoinder counterclaim was filed on or about July 6, 2024. Accordingly, the period of 1 year expires on 5th July 2024. Thereafter, the parties impliedly consented and continued to participate in the proceedings. Extension by a further period of 6 months, which expires in January 2026. Although the claimant has finished its argument, the respondent have not commenced their argument as yet. Accordingly, claimant is directed to seek extension of time for the arbitrator to make
Have
and
you
publish
served?
the award.
Have you served the respondent?
Already, my already, sir. affidavit of service on record.
Take that. Affidavit of service is taken on record. Despite service, none appears for the respondent. Full stop. The present application has been filed by the petitioner under Section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal for concluding its proceedings and publication of the award. Full stop. This court, by order dated 23/8/2023, had appointed the learned sole arbitrator. Full stop. The pleadings were completed on, when was the pleading completed?
Yes, argument already completed on behalf of the claimant.
Learned counsel for the petitioner states that the pleadings have already been completed. It's only for the publication of the award.
No, my lord. Argument on behalf of the respondent has
Respondent has
commenced.
Learned counsel for the petitioner states that the pleadings have already been
Second
completed.
89.
Full stop. The parties, by mutual consent, extended the mandate of the arbitral tribunal by a period of 6 months. Full stop. The said time expired on 5th of January 2026. Full stop. In view thereof, the petitioner seeks an extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the submissions and the material placed on record, full stop. This court, this court is satisfied that there has been no undue or unwarranted delay on part of the arbitral tribunal, on part of the learned sole arbitrator in conducting its proceedings. Full stop. In view thereof, the mandate of the arbitral tribunal is hereby extended for a period of
6 months.
6 months from today. Full stop. The arbitral tribunal is requested to make all endeavors to complete the proceedings and publish the award within the extended time period. With the aforesaid observation, the present petition stands disposed of.
My lord, next two items are similar, my lord. Similar prayer, similar. Same
What
arbitrator.
are the dates?
My lord, next date, my
Appointment dates. Expiry is
same.
same order.
23rd August 2023.
7, 8, 9, same order.
7, 8, and 9. I'm deeply obliged. 7 and 9.
10 is already over.
I'm deeply obliged.
Being for a short passover, Mr. Bagh is
What at this time?
if 5 minutes
Oh,
passover.
who
Mr.
asked for
Bagh is
passover?
reading me in the matter, Mullah. 5 minutes passover.
What is there in the matter?
Well, this matter is there's an 36-2 which has been filed by them. This is an MSME award, which where
36 is
stay, but they have not given a pre-deposit, Mullah. This matter was heard.
how's it maintainable? Your 36.
Yes, that matter will be.
Argue. Tell me, how is it?
Yes, Miss
maintainable?
Lordship, my senior is online, Mr. Umesh
Yes,
Prasad.
Mr. Singh.
Lord, in this case, we had offered deposit on 22nd of February 2023, which was objected by other friend, and the matter continued at their instance. The delay was there. If your lordship will kindly see the order dated 22nd of November 2023.
Page.
Really, what briefly I state that the earlier writ application was filed. It was disposed of with liberty by Honorable Justice Sabyasachi Bhattacharya that you filed this 34th petition within a week. On 13th October 2023, we filed the petition.
Your 34 is going to be entertained only once you have made the pre-deposit under Section 19.
But that we had below offered and was ready to
That's not an
deposit.
offer, sir. You have to deposit before the facilitation center. What offer? Where's the offer? There's a question of any offer, Mr. Singh.
No,
What
but
offer you're talking
in
about?
the court, your lordship kindly see the order sheet below. In the court, it is objected by them that they will not.
Where is the question, Mr. Singh? Where's the question of offer and acceptance and denial? You have to
Yes,
deposit the money before the what is that, MSME center?
That was below. But
Have you
court-
deposited the money or not?
No, not till date. How much now they have given? Kindly see the order sheet. We
Just a
were
minute.
ready with the draft. They,
Sir.
it is on their objection, it was not accepted.
Nobody can object to that. You have to file it before the center. There is no question of any objection.
Then that what the amount, Milord, now they are claiming it 2 crores and all. on the
Sir,
date of
whatever the
filing of-
amount is, this court is not inclined to get into that aspect at all. Have you made the payment or not?
No,
If
we
you have
have not
not
made, we
deposited
are
the
ready
money,
to.
this application is not entertained.
No, it will be entertained only on deposit, that I know, below. And for that purpose, but question for consideration is what will be amount to be deposited is on the date of filing of the appeal. That was 75%. Now, my learned friend has said that deposit 2 crores and all.
Sir, whatever the amount is, in accordance with section 19, you deposit it. I'm not here to do the calculation for you. Whatever the awarded amount is, you know how the rates have to be calculated. It is 15%. You know how it has to be calculated.
Yes, that is 93 lakhs.
Whatever it is, sir, I'm not getting into it. I'm not getting into it. If you want, Mr. Singh, all I can do is I can keep it next week or I'll dismiss it. What do you want me to do?
No, keep it next week. In the meantime, on the date of filing of the appeal, whatever amount we are depositing, we will deposit it.
Mr. Singh, I'm not concerned with the amount at all. I'm only concerned, have you deposited it? Have you complied with section 19 or not? If you have complied, I'll entertain it. If you have not complied, I'll dismiss it. You want me to dismiss it today? I'll dismiss it today.
I am saying
Mr.
that
Singh, you know the law very clearly. Don't try to take it here and there. It doesn't make sense.
No, Milord, it is
Okay,
not
fine.
my fault.
I'll pass an order. You show me. What do you want to show?
I want that let it be in the next
No, let's finish it, Mr. Singh. You tell me. Which
deposit.
No, which order you want to show me? I'll dismiss your application. Show me the order which you want
That
to.
is Milord, when we are saying that we order dated 2nd of November 2023.
Yes, show me the 2nd of November order, Mr. Singh. What is there in that
Yes.
order?
Your losses see the present application.
Yes, Pandey, where is the order?
And next page, your losses will see London Council.
Yes, let me see the order, sir. Let me see the order. Where is the order?
Order file. Next week is correct. We will deposit. We say we will deposit the amount. Even on that day, we are ready to deposit.
Where is the order?
22nd of February.
22nd
22nd of November 2023, we were ready to deposit 93 lakhs. Draft was ready and everything.
This is the copy of the draft that we had already.
They went in appeal, then Supreme Court, all that delay, and now they say that deposit 2 crores. That is, we will deposit it next week. Again, on 7th December order 2003, we were 93 lakh 34 did not accept court. It is there. They said we will don't accept it because they will be contesting limitation matter.
No, we have never said no. More than 2 crores right now. Where is the calculation? Two crores five things.
All these dispute calculation, etc., came because of the orders passed. Otherwise, we were ready always to deposit.
Never. We have to deposit for 2 years.
So your GA1 was allowed in 34 as far as the extension is concerned, right?
Extension.
Condonation of delay.
And
Right.
that also they challenged Millard before the Supreme Court.
It was not decided.
And that for that reason this man.
Mr. Singh, I'm not concerned with that at all. I'm looking only into your application today, which is under 36(2).
Millard, we are ready to deposit the amount.
You
All
deposited, whether you're ready, not ready, doesn't matter to me. Whether it is entertained or not entertained is something which I have to decide today.
But your lordship kindly see that order, previous order.
I've seen the previous
that
orders. I've seen all the previous orders.
Keep it in the next week, we will deposit the amount. 75.
Yes, tell me.
Very small submission.
Yes.
36(2) Milord will only come into operation if there's a 34. The 34 is not there. The intention is very clear, but the GA2. Can you take up that application? That is an application which they have filed.
Yes.
For waiver of this amount.
Waiver can't be.
To 75% field deposit. The application is very interesting. They have created in this application.
Application for waiver we withdraw Millard, we shall deposit that.
Mr. Singh, just a minute. Yes.
That's AP 757.
Yes.
Which is the section 34 petition.
Yes.
In that mirror, that's item 12.
Yes.
In this petition, your lordship will kindly take up GA2.
Yes, waive the
their
condition of
application for waiver of 75% pre-deposit, page 14, Milord.
Yes.
And the reasoning that they have given is paragraph 9 to paragraph 11.
Yes.
The prayer is waiver of condition to pre-deposit 75% of the award dated 12th May 2021. We are in 2026. This they have filed, affirmed on 13th October 2023. This is pending. We are an MSME entity. If this is pending, this shows their intention. The intention is very clear. We don't need to make that payment. That's the intention. Today, Milord, if they've not made the payment, on the last day, Milord, we have also served on them the recent calculation till 3rd of November, which was 2 crore 5 lakhs, 75% pre-deposit. They have not, Milord, bothered to make that payment thereafter, even thereafter. My prayer today is GA2 in AP 757 be dismissed, because, Milord, this is clearly, Milord, against the, give me India Glycols, Milord, against the Supreme Court dicta in India Glycols, where it is now a settled position that this is not a choice.
Yes.
May I hand over India Glycols Limited? Give me a better copy.
This has to be deposited. There's no question of any
My lord.
waiver.
This is, my lord, on GA2. So, my lord, my prayer for GA2 is GA2 should be dismissed. Now, my lord, 36(2), the stay petition. My lord,
Yes.
unless there is a 34, stay petition cannot be entertained. My lord, today section 34 will only breathe life. My lord, if they had made this pre-deposit 2 years back, they have not made the pre-deposit. So today there's no section 34 petition. If there's no section 34 petition, my lord, my prayer today is kindly dismiss the section 36(2). My lord, may I? Paragraph 10 in India Glycols, my lord. It's internal page 3.
Yes, yes, that's what I was
Gotcha.
asking.
And then paragraph 12, my lord.
All right, take down.
This was
GA2, Mr. Singh, I'll dismiss your GA2.
I
36
withdraw it.
Very
So far GA2 is concerned, I withdraw it. We had offered
Um,
deposit earlier also, today also.
Mr. Singh, who are you offering?
Lord,
What do you mean offer? Why are you using the word offer? Who are you offering?
Milord,
You have to deposit the money.
We had gone, Milord, even I can show 3.
Where have you gone? We are not concerned with your going or not going. Please. You have to deposit the money.
We will
Which you have
deposit,
failed to do it.
we will deposit by
2
next week.
days. Day after tomorrow, if you deposit it, come back. Otherwise, I'm dismissing your
Day
GA2
after- day
as well as
after-
your 36 too. Mr. Singh, I'm
Bank
making it
draft
very
has
clear.
to-
Day after tomorrow.
next week रखा है भाई, we can,
नहीं,
how we can
बहुत हो
bank
गया.
draft.
It's been
Your
going on
lordship
for too long.
kindly see the
Singh
bank
साहब, ये
draft.
बहुत हो गया. 2 दिन.
We have given the calculation, my lord, till 3rd of
Bank
November.
draft, we are at Patna. Bank draft have to be prepared at Patna.
I'll dismiss it right now. Give me the file.
पटना में दे करके
I'm sorry,
उसको-
Mr. Singh, you challenge my order.
नहीं
Take
नहीं आप ऐसा कर रहे
I'm giving you time. Mr.
थोड़ा सा
Singh,
टाइम दिया जाए फ्राइडे तक भी कम से
I
कम
had already given time. When was the matter listed last time? You had appeared. You are taking time.
13th
Why
of
didn't you
November
deposit the money?
2025, my lord.
Why didn't you deposit the money?
Lordship, earlier we have prepared the bank draft of 1 crore.
I'm not concerned. I'm not concerned what you had done earlier.
So kindly allow.
Lord, we will deposit. Lord, we will deposit
Mr.
it.
Singh, I have already given time. Do not take the court for a ride.
No, only time that would reach from Patna to Calcutta. That much only
Mr.
time.
Singh, you have taken 6 years from Patna to Calcutta.
No, Milord, that is not in my humble submission. It is your lordship.
Next Monday.
Monday, ठीक
You
है.
don't deposit the money, I'll throw this petition out. Monday. Keep it on Monday.
But we have already shared, my lord, the calculation till 3rd of November with them. Very deep.
Let them do the calculation also. The rest of the matters tomorrow. Monday. Yes, Mr. Banerjee. What is there? Which matter?
I have item 20 here.
That will take.
It's a setting aside, Mullah. They will have to still at the new motion state. So, Mullah.
We'll see that.